Hello friends, this is Vidhika from ixamBee and here we are continuing with our important MCQ series. This is our part 5th and in this series, in this video, we will discuss Indian Contract Act 1872. Indian Contract Act is very important for all the law officer exams. It is present in syllabus of NABARD Law Officer, IBPS SO, RRB, RBI Grade B, FCI AGM Law, SEBI Grade A Law Officer. So this is that part of your exam that you should be well versed with. Let's begin with our first question. Which one of the offers is a valid offer? A garment store gave the following advertisement in a newspaper: special sale for tomorrow only. Men's night suits reduced from rupees 200 to rupees 100. Option B. P says to Q, I will sell you a digital camera. P owns 3 different types of digital cameras of various prices. Option C. An auctioneer displays a refrigerator before a gathering in an auction sale. Option D. A advertises in a leading daily newspaper that he would pay rupees 2000 to anyone who finds and returns his lost dog. Option E. None of the above. So when reading option A to E, you will be able to understand that the correct answer is option D, where A has advertised in the newspaper that he would pay rupees 2000 to anyone who finds and returns his dog. The other option A, B, C are invitation to offer. They are not offer itself. For more clarification, you can read the case law Lalman Shukla versus Gauri Dutt. Moving to question 2. A promised to paint a picture for B at a certain price. Which of the following is not incorrect? Option A is bound to perform the promise himself. Option B, A can appoint some other painter to paint the picture on his behalf. Option C, A dies before painting the picture. The contract can be enforced either by representatives of A or by B. Option D, all are incorrect, and E, none of the above. So the correct answer is option A. Why? Because contract which requires personal volition or quality must be performed by the promisor himself. And here, since we are talking about a personal quality, the skill of painting by A, it is based on the personal quality, personal skill of the person, hence he is bound to perform the promise himself. Question 3 is reciprocal promises means mutual promise, promise for a promise, both A and B, tender of promise, none of the above. The correct answer is C, both A and B. According to Section 2F of the Indian Contract Act, reciprocal promises is a promise which forms the consideration or part of consideration for each other. In other words, when the parties to an agreement make mutual promises to do or abstain from doing something, these are referred to as reciprocal promises. Thus, there is an obligation on each party to perform his promise and to accept performance of others' promises. Question 4 is which of the following is an exception to privity rule? What is privity rule? We will see in the explanation. Option A, estoppels. B, acknowledgement. C, family arrangements and marriage settlements. D, trust. E, all of the above. The correct answer is E, all of the above. All the given options are an exception to privity rule. What is privity rule? Privity to contract means only the parties to contract have a right to sue in case of breach, but when the third party to a contract is due to trust, family arrangement, estoppel, acknowledgement, marriage settlements, then that third party can also exercise such right and hence it becomes an exception to privity rule. Our next question is the following conditions must exist so that a promise to pay for the past voluntary service is binding. Option A, the services should have been rendered voluntarily. B, the services must have been rendered for the promisor. C, they must be in existence at the time when the services were rendered and must have intended to compensate the promise. Option D, all of the above. E, none. The correct answer is D. All of the above conditions must exist so that a promise to pay for past voluntary service is binding. Let us have a look at the explanation. If a person renders voluntary services without any request or promise from another, and the person receiving the services makes a promise to pay for the services, so any person who is receiving the voluntary services promises to pay, then such a promise is enforceable under Section 25(2) of the Indian Contract Act, which states An agreement made without consideration is void. Unless it's a promise to compensate, wholly or in part, a person who has already voluntarily done something for the promisor, or something which the promisor was legally compellable to do, or unless. So let's understand this with an example. Peter finds Noah's wallet on the road. So Peter has found Noah's wallet and he returns the wallet to Noah. Noah promises Peter that I'll pay you rupees 500. This is a valid contract under Indian Contract Act. So the services should have been rendered voluntarily. Here Peter returned the purse voluntarily to Noah. The services must have been rendered for the promisor. The services, that means the return of the wallet, was for Noah. They were in existence at the time when the services were rendered, and Noah has promised to compensate, promised to give rupees 500. Therefore, there was intention to compensate. Hence, the correct answer is D. Moving to question 6. Shreya, a singer, agrees with Rehman for his performance at Gokuldham Society on a specified date. While on his way to Gokuldham Society, Shreya met with an accident and is rendered unconscious. Choose the correct statement. Option A, agreement becomes void on the ground of supervening impossibility. B, agreement is valid and so Shreya is liable to pay damages. C, agreement is voidable and so Rehman has right to claim for compensation. D, agreement is void ab initio. E, agreement become voidable at the option of Rehman on the ground of supervening impossibility. The correct answer is option A, agreement becomes void on the ground of supervening impossibility. This is mentioned in section 56 of the Indian Contract Act and it is known as doctrine of frustration, which says that any act which was to be performed after the contract is made, if it becomes unlawful or impossible to perform and which the promisor could not prevent, then such an act which becomes impossible or unlawful will become void. So there is no need at the option of Rehman or at the option of Shreya. The agreement will become void on the ground of supervening impossibility. Moving to a question 7. Contract of insurance is a contract of. Correct answer is indemnity. Indemnity is compensation paid by one party to another to cover damages, injury or losses. And an example of indemnity would be an insurance contract where the insurer agrees to compensate for any damages that the entity protected by the insurer experiences. So contract of insurance is the contract of indemnity. Moving on to next question. The delivery of goods by one person to another for some specific purpose is known as. The correct answer is A, bailment. This is clearly mentioned in section 148 of the Indian Contract Act. A bailment is the delivery of goods by one person to another for some purpose upon a contract that they shall, when the purpose is accomplished, be returned or otherwise disposed of according to the directions of the person delivering them. The person delivering the goods is called a bailer and the person to whom they are delivered is called bailee. Question 9 is, in which of the following types of contract consideration is not necessary? The correct answer here is B, agency. It is mentioned in section 185 of the Indian Contract Act where we talk about contract of agency, and it is said that section 185 specifically states that no consideration is necessary to create an agency. Thus, when a person is appointed as an agent, his appointment is valid even if there is no consideration. Agency contract may also arise by estoppel, necessity or ratification. Moving on to question 10. This is our last question in this video. I hope this important MCQ series is able to help you in revising your work, in knowing the important parts of the exam. One thing I like to point out here is that all ixamBee mock tests are free. Therefore, go to ixamBee.com, attempt a mock test, analyze your present level of preparation so that you are able to improve further from it. Now coming back to our question. Novation of contract means renewal of original contract, cancellation of contract, substitution of new contract in place of original contract, alteration of contract, none of the above. The correct answer is substitution of new contract in place of original contract. Novation is the act of replacing a legitimate existing contract with a new contract where the transfer is mutually agreed by both the parties concerned. The most common use of novation is in company takeovers or business sales. Here, I would also like to point out that ixamBee provides you preparation guidance for all the law officer exams, be it SEBI Grade A law officer exam, RBI Grade IBPS SO and RRB, NABARD Grade A legal. We have expert legal faculty who guide you, who help you at every step of your preparation. There are live sessions, doubt clarifying sessions. You get study notes, course videos in your courses. Do visit ixamBee.com and look out the demo courses in order to get all the updated information related to government exams, also related to law officer government exams. Do subscribe to our ixamBee channel. Click the bell icon for instant notification. Thank you.